Hi, I'm Richard Harris. I'm a partner at DTM Legal and I'm in the dispute resolution team. We act for a range of clients from startup to PLC, assisting them in various litigation and dispute related matters, helping them to resolve contract disputes, dealing with IP issues, and on a recovery side, looking at the processes and helping them to get paid on time.
What's the difference between litigation, arbitration, and mediation?
So they are the different ways to try and resolve a dispute. So litigation is going to court. It's traditionally going to court. So you've got an issue, and say it's something, a claim that you want to bring. You'll send your letter before action, and you can then issue court proceedings, go to court, and a judge will resolve that dispute. But there's other ways to resolve a dispute. Like we've talked about, court is a timely process, it's a costly process, it's a stressful process. So there's other ways you can look to resolve it. And the court actively encourages people to look at other ways to resolve. And that's something we always look at. And we sit down with clients, look at what do you want? What's your end game? What do you want out of this? And how can we achieve that? And are there different ways to do that? And arbitration and mediation are different forms of alternative dispute resolution. Arbitration is similar to a court in a sense, where it's you have an arbitrator who makes a decision rather than a judge. Arbitrators often are judges; they do two things, but it's done in a private setting, and it's very much certain arbitration rules apply to it. Mediation is a settlement meeting where you have a mediator that goes in between the two parties to try and broker a deal. You often find mediation is probably the most common form of using alternative dispute resolution methods, and it's something we do actively encourage people to get involved in, and certainly try it, because at least you know, is there a deal that can be done that might not be exactly what you want, but is the better than taking the risk and the cost of going to court. Sometimes a settlement is not something you're happy with, but something that commercially you can live with.
Brilliant. So you mentioned there that a lot of arbitrators are judges.
Yeah.
Do mediators then, are they like specially trained for that? Is that something where it's like that is their full-time career to act as mediators?
Yeah, so you have them. So arbitrators can be anyone. It doesn't have to be a judge or anything. But you often find that people, their careers, they will have been barristers or solicitors that have gone into the judiciary. They might do that for a bit, and then they might go into dealing with arbitrations as well, or they might do some part-time arbitrations, part-time judge, part-time being a barrister or solicitor. There's all different career ways. Mediations are similar. There's all different types of mediators. You have some people that just do mediations full-time, some people that are solicitors and do mediations, some people that are barristers and mediations. It's something open to anyone to be able to go down that route.
And are there certain kinds of disputes that you see regularly? Like, are there certain ones where like they make up the bulk of your work, and then there are different disputes that you see much more infrequently? Or
I think say a lot of the disputes come down to contract. Contract and money are generally what people get into disputes over. And what you find is different is the businesses themselves are different, and the facts around those contracts are different, and obviously different contracts trying to achieve different things. So the majority of what we will do will be contractual disputes. We're sector agnostic in the sense that we can act across any sector, dealing with the contracts from there, because that's what it all often stems down to, is contracts and money.
So my next question was, are there certain or common mistakes that people make when like a member of the public thinks about resolving disputes? Yeah, I'm guessing that quite often links to their contract should kind of present a solution immediately, and it doesn't.
Yeah, I think sometimes a misconception can be that you will send correspondence from a lawyer and that will resolve it. Sometimes that does. Sometimes that's all it needs. But sometimes there is someone else on the other side who doesn't agree with the position that's been adopted, and that's where you then that's what your lawyers are then trying to do, is trying to see the way to resolve that. whether it's by mediation or other forms of ADR, or whether it's ultimately something that we'll have to go to court to resolve this. So I think sometimes the misconception is that there isn't always a quick answer or a quick win.
And then, what advice would you give someone then if they've got a commercial dispute, it's the first time they've had one, and they're thinking, where do I begin? What do I do? What's that kind of first bit of advice you give to them?
They need to talk to the lawyer. Is the first one. Talk to someone they know, someone they trust. It might be that they've got a lawyer that they act for on the corporate side or the property side. Speak to them, see who they recommend. Speak to others, speak to peers. Who have they used? You can obviously do a Google look online and find dispute resolution lawyers, but it's always good, I think, to use someone through word of mouth and build up that trust there. And then I would say then speak to them, get to know them, perhaps come into the office and see them, discuss the dispute in general terms, the process and next steps, and then decide whether you then want to engage. That initial conversation should get a bit of an idea of costings, what the first steps are, what the approach is going to be. And it might be that the first step is, well, okay, we see the argument here, we need to review X, Y, and Z, and then we can advise on whether this is worth pursuing or not. But it's always worth just having initial conversations.
So it seems like it's like a very practical approach to resolving a dispute, but obviously inherently disputes are quite emotional.
Yes.
Is there a bit of an art to handling cases where emotions are involved, or perhaps someone is just completely unwilling to compromise because they've reached their conclusion and it kind of doesn't matter what facts are presented to them?
Yeah, there is disputes, and depends on the nature of the businesses and the people you're acting for. But disputes can get a personal element to them, and people get entrenched in their positions. They get quite invested in it, and often it's trying to break down that and looking at the commercial reality of it, and setting out clearly and speaking to a client and not being afraid to say, this isn't worth it. You can spend your time and money on something better than dealing with this dispute. Resolving it now for X is much better than fighting it to achieve Y. And it's been open and having that conversation and not being afraid to tell someone if there are reasons why this may not be worth pursuing.
And do you find that then sometimes clients will come to you where they've taken quite a lot of steps towards trying to resolve a dispute with another party, and perhaps even the other parties tried to work with them initially, and they've almost explored quite a few options before they get in touch with.
Yeah, and it's often when you speak to them initially, you'll get to know what informal steps they've taken as well. Now, if they haven't made any informal approaches, that can sometimes be a way to do it, with the thing saying, look, I've spoke to my lawyers, I want to try and, if we don't get this sorted, they're ready to go. And sometimes that can help move things along a little bit before you go full, get the lawyers involved. So it's definitely worth exploring informal attempts to try and resolve yourself. And if you're not getting anywhere, then you look to raise the bar.
And then, is there some common mistakes you see where people have tried kind of exploring options themselves and it's led them to making a mistake that is perhaps harmful for their situation?
And it can be, and this is why it's useful to speak to your solicitors beforehand, just to get an idea of how you should approach those informal conversations. Particularly if you've got a good relationship with a law firm. I know we'd always be more than happy to do this with our clients, is just have a conversation initially, a 5-10 minute chat about something that's come up and how you're approaching it, because you might have issues that come arise where you make a concession that you wouldn't have intended to make, a concession that might prejudice you further down the line, and there's ways you can do that without prejudicing yourself. So it's understanding that and knowing that. So that 5-10 minute conversation with your solicitor before you begin then could be quite useful if you're not used to doing it, if it's something new.
You mentioned that a lot of the disputes that you see, obviously it's relating to money or contracts. What would be your advice to someone who perhaps has been presented with a contract, maybe a commercial contract, and they're not quite sure on it, or they're not certain about some of the terms? or the kind of what's been laid out in the contract? What's your advice to them then?
You should only be entering into signing contracts if you understand what it is you're signing. It won't be an excuse further down the line if you say, I didn't understand that. The onus is on you. So if you're not understanding something, go and speak to your solicitor. Now, it'll likely be your corporate commercial solicitor that you'll be wanting to speak to get advice on it, but that might also be in connection with a litigation solicitor as well, looking at it from the perspective if it goes wrong. I know we work closely with our corporate and commercial team with clients to advise on contracts, and we do that from the corporate commercial perspective, but also from the litigation eye. Having both of that review of it can be very useful. So if you are unsure as to what a contract says, what that means for you, how it impacts you, you should take advice on it. You often see situations where people have entered into contracts and they've not understood them, and they might be trying to get out of it 1, 2, 3 years down the line and haven't understood how to get out of it or the consequences of trying to get out of that contract.
Do you think there's just that people are kind of unwilling to have confrontation, almost to turn around and say, I need time to review this, or like people just assume that a contract will be sound and they sign that without thinking that they should double check?
I think there can be a little bit of both. I think there's a little bit of time pressure, wanting to get a deal done, a sale done, whatever it may be, and not taking the time to review and understand. There can be a little bit, like I suppose, like how a lot of people are, including a lot of lawyers in their personal life, will never read terms and conditions if they're shopping online and things like that, and that can perhaps carry over sometimes into commercial context. But just to reiterate, it's so important that you don't enter into a contract if you don't understand it, because that could really cause you issues further down the line because you could have agreed to something that you'd never intended to.
So if you could give one bit of advice to you've got a megaphone, every member of the public's going to hear you, what's that one bit of advice you'd say to people then to kind of just follow in their day-to-day lives?
So from a commercial perspective in a business, one of the big things that we talk a lot to with clients, and again this is in collaboration with our corporate commercial teams, is having good terms and conditions, using your terms and conditions, and making sure you incorporate those terms and conditions into your contracts. You can have a great pair of terms and conditions prepared, but if they sit in your desk drawer, they're of no use to anyone. You need to make sure they form part of your contract, and that's so important that you have the processes in place to do that. And a lot of businesses can sometimes not think about that, and they only think about it when it goes wrong. But if you spend time at the outset doing it, you can put yourself in a much better position should you then enter into a dispute.
If a business is thinking, I need to talk to a dispute solicitor, I need to talk to an expert, what's the kind of information that they should have kind of thought about or bring with them to a meeting or to a discussion to make sure that they can kind of answer the questions that you'll have for them?
So a lot of it comes back to one of the first questions will be, what's your contract? What are the terms that you're trading on or you're doing business on? So if you've got a written contract, bring that, make sure you've got that. If you've not got a written signed contract, things like invoices or other back and forth correspondence that you've had where you've agreed to it, all that, because that will be the starting point, is understanding what the relationship is between the two parties. That's where it all stems from. Once you understand that relationship and the terms that govern that relationship, you can then look at how the dispute goes from there.
So do you then get many cases where you think a client is probably right, but poor record keeping kind of lets them down?
That can be an issue in a lot of cases, that what's been said all makes sense, but there isn't the documentary evidence to prove it. And one of the starting points for the court and a judge is looking at the contemporaneous documents. So the more documentary evidence you have, the more likely you are and the better position you're going to be in to prove your argument.
And then I know we spoke about kind of people trying to explore kind of informal negotiation and informal discussions at the start. Is it better to try those kind of resolving a dispute on your own, or is it better to just straight away go and talk to a solicitor, have that kind of initial conversation with a solicitor, lay it out?
I think it depends. Again, this is, and I mentioned this at the start, there isn't a one size fits all approach. Now, you might be a business person that is very much used to and has had a number of disputes and these before, and you know how it works, and you can go off and have those conversations and try and resolve it yourself. We have a number of clients that are very experienced in that, and we know that if they're coming to us, they've exhausted all possible means. Or it could be the first time that you've entered into a situation, and in that case, I would say go and have a 5-10 minute conversation and just understand a little bit more about the processes, things you should say, shouldn't say, and how to protect yourself. So it very much is an individual answer to that. There isn't a general one that you should do. It's very much how you are.
Is there anything in particular you wish people understood about the English legal system, or like some basic information that people generally you find kind of have missing from their knowledge?
I think a lot of the legal system is, particularly in more higher value disputes, is how it works and how it's quite a time consuming process. It takes a while to get a matter all the way to a trial if it's going to go there. There isn't a quick solution in the court. There's certain applications that can be made to try and speed it up and things, but they're very much fact specific to certain matters. They're not always appropriate. So it's a little bit more about, I suppose, understanding that process, and that's where it comes back to, if you're new to it, having that initial chat with your solicitor to understand that, oh well, you might think, oh, I'll take this to court, but do you understand what that actually entails doing that?
What is one misconception people have about solicitors from TV shows?
One of the things with when you see lawyers and law firms on TV is they're often American, and it's dramatized for TV and it's American, so the system and the way it operates is very different. So, for example, the courtroom dramas that you see when we're in court over here aren't quite the same as that. It's a lot politer. It's a lot more time just reading through and taking a judge through documents. So whilst it is an exciting part of the job being in court, it's not quite as dramatic as the TV shows suggest.
So phrases like objection and I rest my case and stuff like that, you're not necessarily going to courtrooms and shouting that.
No, you will never be saying objection or I rest my case, and I think the judge would laugh you out of the courtroom if you tried.
So what's the most unusual or surprising case you've worked on?
We have a wide ranging caseload that we work on, and one of the great things about litigation is the dispute can be about anything at all, and you have to get to know each individual business that you're working with, and you have some unusual businesses that do unusual things. I was involved in a very intensive dispute a number of years ago to do with processing sand through a machine to go into glass, which sounds incredibly dull, but produced an incredible, quite an interesting legal dispute.
Do you find that happens often then, where you perhaps, when you first look at something on paper, you think, oh, there's not much there, or it's not going to be a particularly complicated case, and then as you get into kind of working on it, it kind of completely evolves into something else?
Yes, yeah, no, certainly does, and often evolves when you're getting into the facts of it and getting to understand a business themselves and what they do. We had a weird and wonderful one involving a seller of certain products, and a cat had got stuck in one of the products, and the person that was buying it was bringing a claim as a result of damage to the cat. So it all very much depends on the particular business and the facts, and that's a great part of it, is getting to know what a business does.
So talking of the weird and the wonderful, what's the strangest place you've ever been asked for legal advice? I presume on nights out and stuff like that.
Yes,
quite often.
Yeah, you get it every now and again. Now you obviously you can't just go around giving legal advice, but you often find once family and friends know that you're a lawyer, you will get that question coming up at the end of a conversation, usually at a Christmas party. Towards the end, it'll just say, "Oh, but I had this issue with my car," or something like that will crop up.
So if you know when you're at social engagements, you're going to get asked questions sometimes. What is the best way to relax at the end of a tough day working as a solicitor?
For me personally, it's home time with family, spending time with the boys and my two kids, my wife. Usually taken up with the kids after school clubs such as football and things like that. And often you can't beat a beer or a glass of wine after a hard week.
Have you ever had that your kind of legal skills have come into use in situations where you wouldn't expect it? So, like, say you mentioned like your kids at sports clubs or stuff like that. Is there times where you're like, oh, didn't think I'd be using those like skills today?
Yeah, it comes up. So often you see ears prick up if you go into a meeting. So I coach one of the football teams. So you go to a coach's meeting, it comes up what I do. And the committee of the football club ears often prick up and think, and you can see, oh, how can we get him involved? And if we've got any issues, we know where it's going to go. There are other incidents as well. It's cropped up for me when I've been abroad, and someone's required help, and they think the phone call comes to me, oh, you're a lawyer, you can help someone who's in trouble in Spain, which was able to help, but not through actually being a lawyer.
Do you ever then get asked, and I guess this kind of comes back to like the misconceptions question, but like legal myths where people ask you stuff and you're just like, that's just not true at all?
Yeah, well, I think there's two things. There's myths that people doing a bit of Googling will say, I know this is the answer, and it's not. Or they think that you know every law in the country, is the other one. And you have to explain that, no, this isn't an area that I do. No, normally it's things like family or criminal or selling property. They think you know all of that or do all of that as well.
I know a lot of the like media that we have, obviously, particularly when it comes to like legal media, it tends to be American.
Yes.
Do you find that you actually enjoy any of those like dramas, or do you just find them infuriating?
No, I quite like them. I always watch them with a smile, whether it's a film or a TV show. You see moments in them that relate to what it's like sometimes. For example, if you when we're going for an injunction, whether going for one or defending one, they're very fast paced, very urgent. Usually a lot of work in a short space of time, and rocking up at court and asking the judge to do something quite urgent, quite drastic. So they're the moments where it's a little bit like the TV. So you do see glimpses of it, but no, it doesn't bother me watching them. I do watch them with a smile.
And you're not always like correcting them when they're on, or?
Yeah, I do have sort of certain things that you try and correct, particularly the ones in the English legal system, that when they dramatise it and they try and make it more like the American one.
So kind of moving a bit more onto then your life as a solicitor and kind of working as a disputes resolution solicitor. What does a typical day look like? You mentioned there's a lot of researching and actually doing work. It's not just like the dramas.
No, so a lot of that and I think that sort of goes back to earlier as to what's missed from the TV shows is all the preparation work that goes into it. The exciting bit, if you will, is when you're in court or you go into a mediation, for example, trying to settle it, or without prejudice meeting. But they don't just happen overnight. There's a lot of work and a lot of build up, and often, for example, if you go into trial, it's a two year build up in that, and it's preparing the documents, preparing the statements, understanding the documents, managing a case as well. So you've got to manage clients, you've got to manage counsels, that relationship. You bring experts in, you're managing experts as well. You're bringing everyone together. You're managing the client's legal team essentially, and attempting or looking to give the client the best possible chance to resolve the matter and be successful in court. So day to day, that's one of the great things I like about the job. It changes a lot. No dispute is ever the same, even if you can have similar arguments over the similar documents or the similar factual situations. Everyone is slightly different. So I always don't think no day is ever quite the same.
So obviously you mentioned, or you said there's a lot of like build up to the day in court. Is it then when you have a successful day in court, is that the most rewarding part of the job, or is there other parts of the job that kind of stand out to you as being quite satisfying?
Yeah, that's a good example. That's always, if you know you've had a good day in court, you do come out with a good buzz, and the first pint after a good day in court is always a good one. Um, but that translates to other things as well. You might have a day where you've been preparing a witness statement, and it comes together and it reads really well, and you're really pleased with that piece of work. That's quite satisfying when you get that completed, or you've had a successful mediation. Usually, the sort of the most satisfying parts are when you've got a big task completed, like I say, whether it's a disclosure, a witness statement, or that part of court.
So then obviously you get those rewarding moments in work, but I imagine there's still a bit of a challenge to balancing like work-life balance, and like you've just been down to London now to work on the case in
Yes.
London. Is it kind of particularly challenging to balance work-life balance, or are there good opportunities where you get stints where you don't have to particularly travel away, or it doesn't particularly?
Yeah, you get highs and lows in the sense that you will have really busy weeks. For example, what you mentioned there, I was in London for um, over a week for a trial. So obviously that takes you away from home, takes you away from family. Got another one coming up shortly where I'll be in Wales for a week for a similar sort of thing. But then it might be a good number of months before there's anything else like that. And it's knowing your times, and there will be times when like them where it overtakes a little bit, but then you'll get other opportunities where the part, say if you're dealing with a matter, there's certain parts of court preparation, for example, that are more intensive than others. So the less intensive times, you take advantage and balance that work life at the appropriate times to make sure you're ready and rested for when it does peak, that you can do the work that's needed, and then at the times when it's a little bit quieter, and you can have that family time as well.
And then obviously you spend so long preparing to take a case to court. Do you find that obviously before you actually go into that courtroom, you're kind of having to psych yourself up, you're having to like mentally prepare yourself to go in there? Is that something you particularly see with juniors when they're kind of learning the rule and they're getting into the team, that people put a lot of stress on themselves then when it comes to court day? Or do you think the preparation that beforehand kind of helps settle that?
Well, it should be the latter, really. By the time you go into court, you should be well prepared as your team. You'll have counsel with you. You'll be going as well. You'll know your documents. You'll know your arguments. So you should be going into this well prepared. So that you're not having that feeling going into court. There's always an anticipation, because there's an inherent risk with litigation and the judge on the day that things might not go your way. So there's always a nervousness in that sense, but not in the sense of what you've done. You should always be going to court knowing that you've put everything you can into it, and you're putting the best case forward that you can do.
Do you think the kind of nature of disputes work will attract certain characters, or like if you were a trainee solicitor, would you be attracted to different kind of specialisms if you weren't able to cope with those kind of more stressful situations?
We often say this with trainees. You try your litigation seat, your litigious seat, you try your non-contentious seat, and let people know whether they're a litigator or not. And some people, which I would fall into, sort of thrive off that and love that, the way litigation works. For other people, it's not for them. Obviously, everyone's different, and it's very much a personal decision. So anyone going into it, you need to spend time looking at litigation, doing litigation, and spend time doing non-contentious, and you will know yourself. You will get a feeling yourself. When I started, I thought I would be more non-contentious, but as soon as I did litigation, I had the book for it, and that's what I've done for nearly 15 years.
And is there times during the workday then where you kind of get a bit more downtime? Is it all flat out trying to get a case done as quickly as possible, or because litigation cases, as far as I understand, can take quite some time to go through. So I presume there's kind of peaks and troughs where
there's peaks and troughs in them, and you have a wide case as well. You don't just do one case at a time. You'll have a number going on, but that's why we have a team, and you have a great team that supports and works around you. So it's very much peaks and troughs. You might have a spell where you've got a number of hearings in 1 month, and you know that kind of that month and the month before building up to that are going to be particularly busy. You might then have a lull where you've not got any hearings or court deadlines particularly approaching, and that's a quieter month, and you can get on top of other things. But there's usually in a case, there's usually something that we'll need doing, whether it's updates to clients, correspondence to the other side. So it's rare that there's nothing to do on a particular case at stages, but it does have peaks and troughs as to when it's busier and not.
And I suppose thinking about disputes as well, you kind of think about it of you're having a dispute with the other side, but are there times where it's particularly challenging to handle the clients that you have as well, or handle their expectations and their needs?
That's an important part, and it's an important part of a solicitor's role, and it's one of the distinctions between solicitors and barristers. Barristers will present the arguments at court, but the relationship and the management of the client is a very, very crucial part of the solicitor's job. And that comes to that point I mentioned earlier in terms of managing the legal team and managing the case. So you manage the expectations of the client, not in terms of not just expectations of prospects of success, but expectations of how long this takes, how costly it's going to be, how intensive of work it's going to be, not just from our side, but what you'll need from the client as well. Managing that relationship between barrister, solicitor, client, experts that come in. So that it's a very important part of that. And that's where you need to build up your relationship with your client so that they're trusting you, that you're supporting them as best you can through that process.
And I suppose most people would hope they never need the services of a disputes resolution lawyer, although I imagine in the commercial world it's a bit more kind of commonly accepted as kind of a service that is required. Do you find that when clients first get in touch with you, there's quite a lot of education that does need to go into it as to what disputes resolution is and kind of what's involved with it?
Yeah, you're right in the sense that, particularly in the commercial world, at some point or another in a business's life or a business person's life, they are likely to run into some dispute at some point and need a dispute lawyer. We often say, and when we're talking to people and new clients, that you really day to day you want to be talking to our corporate teams, employment teams, property teams. They're doing your transactions, they're doing the nice stuff. You don't want to talk to us as much because that's when something has gone wrong. Not necessarily that anyone's fault or anything, but something's gone wrong. But it happens. It'd be rare that anyone goes through the life cycle of a business or a career without running into a dispute. So it's important to have that relationship that you can speak to the person that you want to and trust that they will take you through that process. Someone who's been through litigation before knows it a bit more and a bit more wise to it. Some who are completely new to it will need that understanding of the whole process and a little bit more hand-holding. But you get to know that. It's all about knowing your client and providing them with the support that they need that's specific to them. Is one of the good things about the job. There's not a one-stop-fits-all approach. It's very much bespoke and tailored to a particular client.
So I guess you again, then you have like one of those situations where like you can have a good win for a client. That client very much is like, thank you, I hope I never have to talk with you again.
That is quite a common email exchange at the end of a matter where thanks, got what we wanted. Hopefully don't have to talk to you again. And it's always taken in good spirit, and we say yes, no. Hopefully we can talk to you if we can meet going out, so from a networking perspective, but hopefully we never have to talk.
And that was my last question. So it's just, what do you have planned for the rest of your day?
Today is preparing for the next matter, which is a public inquiry on a planning appeal in Wales coming up shortly. So we've got a number of experts, planning specialists who all need who are currently preparing their proofs of evidence. So that's this afternoon.
Yeah, sounds fun. Right, thanks for your time.
Thank you. Thank you for watching. Visit the DTM Legal website for more information about our services, or why not connect with us on LinkedIn or follow our new YouTube channel.